Hello, lawyers and learners. In the last few lectures, we studied the uncodified background of Hindu law. We discussed who is a Hindu. We discussed the sources of Hindu law. We also discussed Mitakshara and Dayabhaga schools. And in the last lecture, we specifically discussed doctrine of pious obligation. Now, why did we study all this? We studied it because Hinduism did not initially have any specific written book of statutes. Hindu law has a long background of religious texts, custom, practices, schools of law, judicial decisions, and social reforms. But from this lecture onwards, we are entering into the codified part of Hindu law. And the first major act that we are going to study in this will be the Hindu Marriage Act of 1955. Now, before reading the provisions of this act, I want you to understand one thing very clearly. We are not going to study this act section by section like reading a bare act line by line. That approach is useful at some places, but for understanding law properly, especially for students and practicing lawyer, a concept-wise approach is much better. So first, we will take a concept, then we will understand the legal issue behind that concept, then we will connect it with the relevant section of the act, and after that, wherever required, we will discuss relevant case laws and practical examples. For example, when we study registration of marriages, we will not simply read section 8 and stop there. We will find answers to specific questions such as why is registration important? If a Hindu marriage is not registered, does it automatically become invalid? What is the evidentiary value of a marriage certificate? Can the registration cure the defect if the marriage itself was not properly solemnized? These are the kind of questions that actually matter in law. So that will be our method throughout this series. We will study concept-wise and not section-wise. Now let us first understand why marriage is so important in personal law. Marriage is not merely a private arrangement between two individuals. It is not only about one man and one woman deciding to live together, what is called as cohabitation. Once a marriage is recognized by law, a legal status is created. The parties acquire the status of husband and wife. And with this status, several legal consequences also follow. There may be questions of maintenance. There may be questions about custody of children. There may be further questions like legitimacy of children, inheritance and succession, and questions about matrimonial remedies such as restitution of conjugal rights, judicial separation, divorce, and maintenance. So marriage does not affect husband and wife only, it also affects the children and the entire family. It affects property rights, it affects social recognition, and if we see it from a wider perspective, marriage also affects society as a whole. So now let us first understand why marriage is important in personal law. Marriage is not merely a private arrangement between two persons. It is also not about one man and woman deciding to live together, what is called as cohabitation. Once a marriage is recognized by law, a legal status is created. The parties acquire status of husband and wife, and with that status, several consequences follow. There may be questions of maintenance, there may be questions about custody of children, there may be questions about legitimacy of children, and there may be questions such as inheritance and succession, and also about matrimonial remedies like restitution of conjugal rights, judicial separation, divorce, and maintenance. So marriage does not only affect husband and wife, it also affects children, and it affects family and society as a whole. That is why marriage has become a central topic in almost every personal law. Whether we talk about Hindu law, Muslim law, Christian or Parsi law, or any other personal law for that matter, marriage has become a very important central topic. Now in the Hindu law, marriage has traditionally been treated as a sacrament. This is very important point. Hindu marriage was not traditionally treated as a contract. It was connected with religion, and it was connected with sacred duties and family obligation. It was also connected with ceremonies, rituals, social recognition, and spiritual ideals. So traditionally, Hindu marriage was considered a sacred union. But at the same time, when we look at the modern law, we cannot stop only at the word sacrament, because the moment marriage is recognized by law, civil consequences also arise. For example, if the marriage breaks down, the parties may approach the court for a divorce. If one spouse has no independent income, the issue of maintenance may arise. If there are children, custody and guardianship issues may also arise. If the marriage itself is challenged, the court may have to decide whether it is valid, void, or voidable marriage. If one party remarries during the subsistence of the first marriage, the issue of bigamy may also arise. So the better way to understand Hindu marriage is this. Traditionally, it has a strong sacramental background, but modern law regulates its civil and legal consequences. Therefore, we should not oversimplify it by saying that Hindu marriage is only a sacrament and nothing else. And we should also not say that Hindu marriage is merely a contract. Both statements are incomplete. The correct understanding is that Hindu marriage has a sacramental foundation, but the Hindu Marriage Act gives it a modern legal structure with rights, duties, remedies, and consequences. Now, at this stage, we must understand the role of ceremonies and customs. In traditional Hindu law, ceremonies were very important. Some marriages were performed according to Shastric rites. Some were performed according to customary rites. And even after codification, ceremonies did not become irrelevant. This is very important point. The Hindu Marriage Act does not say that ceremonies have no value. In fact, Section 7 deals with ceremonies for a Hindu marriage. It says that a Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either parties. So the law recognizes customary rites and ceremonies. Now, one ceremony that we often hear about is Saptapadi, but we must be legally accurate here. Saptapadi is not to be spoken of casually as if it is customary in every Hindu marriage, in every community and in every situation. The Act says that where such rites and ceremonies include Saptapadi, that is the taking of 7 steps by the bridegroom and the bride jointly around and before the sacred fire, the marriage becomes complete and binding, and it becomes complete with the 7th step that is taken. So the point is this: if Saptapadi forms part of the customary rites applicable to the parties, then its performance becomes important. But the larger legal point is not merely about Saptapadi. The larger legal point is about solemnization according to the customary rites and ceremonies of either parties. This distinction matters because in actual matrimonial disputes, court may have to examine whether the marriage was properly solemnized, whether necessary ceremonies were performed, whether the recognized customs existed, and how the marriage is proven. And this is why the recent decision in Dolly Rani versus Manish Kumar Chanchal in year 2024 becomes very important. The Supreme Court emphasized that Hindu marriage is not just social event, not just a celebration, and it's not just merely about getting a marriage certificate. There must be proper solemnization according to law. So for a valid Hindu marriage, one must look at the conditions of marriage, the ceremonies, the custom, the proof, and also whether solemnization has taken place or not. Now let us come to another point, and that is about the old forms of marriage in Hindu law. Before Hindu Marriage Act, there were old classification and old forms of Hindu marriage. Ancient Hindu law discussed different forms of marriage. These classifications were useful from historical point of view. They show how Hindu marriage developed through religious and social practices. But for a modern student of law, we should not get lost into this ancient classification at the beginning itself. Today, the court is not primarily asking whether marriage falls under an ancient category. The court is asking questions such as, does the marriage satisfy the requirement of Hindu Marriage Act? Were the parties governed by the act? Were the conditions of the valid marriage fulfilled? Were the required ceremonies performed? And is there any proof of marriage? Is the marriage valid, void, or voidable? These are the modern statutory questions that the court addresses in today's era. So historical background is important, but the statute is decisive and has legal binding. Now let us understand why codification became important and necessary. Before codification, Hindu marriage could depend on religious texts, commentaries, schools of law, local customs, community practices, and judicial interpretations. This created some uncertainty within society. Different communities had different practices. Different schools had different approaches. Many rules were scattered. Many rules had to be discovered from text, customs, and case laws. For a student, this makes the law difficult. For a lawyer, this makes legal advice difficult. And for a court, this creates uncertainty. And for ordinary people, it creates confusions about rights and remedies. Codification helped to bring clarity. It helped to bring uniformity in society. It helped to bring about reform. And most importantly, it gave statutory remedies. Now remember one thing. The Hindu Marriage Act did not appear suddenly in isolation. It came as a part of wider movement of social reform. Before and around this period, Indian law had already seen reforms relating to, say, widow remarriage, child marriage restraint, civil marriage, and recognition of marriage beyond strict caste and sect barriers. So the Hindu Marriage Act of 1955 should be seen as a part of that large reform movement. It codified the law relating to the marriage among Hindus. It also modernized many aspects of matrimonial law. One major reform was monogamy. Before codification, monogamy was not a strictly statutory requirement among Hindus in a way it is today. In many situations, a Hindu man having more than one wife was socially accepted and legally tolerated, while a woman having more than one husband was not treated in the same way. So there was gender inequality. The Hindu Marriage Act brought a major change. Section 5 requires that at the time of marriage, neither party should have a spouse that is living. So the law is now expressed equally for both the genders. It is not merely saying that women cannot have two husbands. It is also saying that a man cannot have two wives. Neither party should have a spouse living at the time of marriage. And Section 17 connects this with penal consequences in cases of bigamy. So this is not just codification. This is also social reform. Now we should also understand Section 4 of the Act because it shows the importance of codification. Section 4 gives overriding effect to the Act. In simple language, where the Act applies, any text, rule, interpretation or custom which is inconsistent with the Act cannot override the statute. This is very important because once the law is codified, the statute becomes the starting point. Custom may still matter in certain places, especially where the Act itself recognizes customs. But custom cannot defeat the clear provision of the Act. So when we study codified Hindu law, our first question should be, what does the Act say? Now let us understand the broad objective of Hindu Marriage Act 1955. The objective is to amend and codify the law relating to marriage among Hindus. This means that the Act does two things. Firstly, it collects and places the law in statutory form, and secondly, it reforms and modernizes the law wherever necessary. The Act deals with who is governed by it. It deals with the conditions of a valid Hindu marriage. It deals with ceremonies, registration. It tells us which type of marriage is void and which is voidable. It also deals with the restitution of conjugal rights and judicial separation and remedies such as divorce and mutual divorce. It also deals with bigamy. It deals with maintenance and permanent alimony. Custody of children, jurisdiction, and matrimonial reliefs are other things that are covered under this Act. So this Act is not only about how marriage is performed, it is also about what happens when the marriage is questioned, when the marriage breaks down, when one spouse seeks relief, when children are involved, and when the property and financial issues arise out of a marriage. Now let us very briefly look at the important sections which will guide our future lectures. These bare acts you will have to refer for this, and bare acts you will also find on our website. If you go to all bare acts section, you will find bare acts here within these bare act list, and also you can scroll down on this page to see all the related bare acts. Here you can see Hindu Marriage Act towards the left. So now let us cover important sections one by one. Firstly, we have section 2, which deals with application of the Act. This helps us understand who is governed by Hindu Marriage Act. Section 3 contains definition. Definitions are important because sometimes one word in the Act may decide the entire legal issue. Section 4 gives overriding effect that we already discussed. This tells us that where the Act applies, inconsistent old laws, customs and usage cannot prevail over the written codified statute. Section 5 is also very important and it tells us the condition for a valid Hindu marriage. When we discuss validity of marriage, bigamy, prohibited relationship, sapinda relationship, mental capacity and age of the parties all these become very important and central. Next, section 7 deals with ceremonies for a Hindu marriage. This will be important when we discuss solemnization and proof of marriage. Section 8 deals with registration of Hindu marriage. Here we will discuss a very important and practical question, that if a marriage is not registered, does it become invalid? Secondly, we will also address the question that if a marriage is registered, does it automatically become valid? Now, these two questions may sound similar, but they are actually different questions. Registration is important for proof and record, but registration and validity are not always the same issue. Next, section 9 deals with restitution of conjugal rights. The restitution of conjugal right, also abbreviated as RCR, is a matrimonial remedy where one spouse says that the other has withdrawn from the society of the spouse without a reasonable cause or a reasonable excuse. Section 10 deals with judicial separation. Judicial separation is different from divorce. In judicial separation, the marriage is not immediately dissolved, but the parties are legally relieved from the obligation of cohabitation. Section 11 and 12 deals with void and voidable marriages. This distinction is very important. A void marriage and a voidable marriage are not one and the same thing. We will study this separately with examples. Section 13 deals with divorce, whereas Section 13b deals with divorce by mutual consent. These are central provisions in matrimonial litigations. Section 17 deals with punishment for bigamy. Section 24 and 25 deal with maintenance and permanent alimony. Section 24 is about maintenance pendency light and expense of the proceedings. Section 25 is about permanent alimony and maintenance. Finally, Section 26 talks about custody of the children. This becomes important where matrimonial disputes affect children. Section 27, about which I have not written here, deals with disposal of property presented at or about the time of marriage. Section 19 deals with jurisdiction, and jurisdiction is extremely important in practice because before filing a matrimonial petition, a lawyer must know where the petition can be filed and where it will be entertained. So this is the roadmap that we will follow. We are not going to finish all of this in one lecture. Today's lecture, I am giving a broad outline about what path we will follow. The purpose is to understand why this act, that is Hindu Marriage Act 1955, why it matters, why codification was required, and how we should approach the study of this act. So let me summarize today's lecture. Hindu marriage has a traditional and sacramental background, but modern legislation regulates the civil consequences. Marriage affects not only husband and wife, but also children, family, property rights, maintenance, custody, legitimacy, and succession. Ceremonies and customs continue to matter, especially under Section 7, but their importance has to be understood through the statutory framework. Codification became necessary because the earlier law was scattered across texts, customs, schools, and judicial interpretations. The Hindu Marriage Act brought clarity, uniformity, reform, and remedies. It also introduced important statutory changes, especially rule of monogamy. And from the next lecture onwards, we will start studying the act concept-wise. We will begin with registration of marriages in Hindu law. And the main question in that lecture will be, does non-registration make a Hindu marriage invalid? An equally important question, does registration alone prove that valid Hindu marriage took place? So keep a bare act handy. Do not study this act word by word. Study it concept-wise. Understand the problem first, then read the section. Then apply it to the facts. That is the correct way to study. That is it for this lecture. See you in the next one. Thank you.